in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning. On behalf of Judges McClarty and Davis, welcome to the Court of Appeals. This hearing on Zoom will be conducted just like a hearing in court. And if we have any technical problems, we'll pause, work them out, and finish it up. So it'll be okay. If there are no announcements, Mr. Hivner, would you call the first case?
Edward Gilbert et al. Versus State of Tennessee.
Okay.
Good morning.
Good morning.
Good morning, Your Honors. Are you ready for me to begin?
Oh, you may begin.
Oh, sorry. As I said, good morning, and may it please the court. My name is Josh Walker. I represent the state of Tennessee in this matter. We're here today over a defective certificate of good faith filed in a healthcare liability action. I will tell you at the outset, I'm much more interested in trying to answer any questions that the court may have than stunning everyone with the dulcet tones of my voice. So hopefully I won't talk for too long, and hopefully if you have questions, I can answer them. Very briefly, this complaint was filed back in May of 2020. There was a certificate of good faith attached to the complaint, but it had a caption, although it said in the Claims Commission of the state of Tennessee, it listed as the defendants a private non-state employee doctor and a non-state hospital who are defendants in a related action filed in the Hamilton County Circuit Court. So it didn't have the state of Tennessee. It didn't reference the resident physician who was alleged to have been negligent. The state filed a motion to dismiss. Some 3 months later, after the claim transferred from the division to the Claims Commission, as part of the response, the claimant filed the statement of a Dr. Preston Miller that was apparently the basis of the certificate of good faith. There's some dispute among the parties in their briefs as to whether the commission relied on this statement. All I can say to that is the claimants filed it in response to the motion. The commissioner considered and discussed that statement in his order denying the state's motion. And the claimant had
counsel, was a statement intended to, or did it make a reference to amending the initial certificate of good faith?
No, my understanding, it was filed just as to demonstrate that the underlying physician statement for the certificate of good faith did exist, but I don't think it purports to be a certificate of good faith itself.
Okay.
I don't believe.
So as of today, the record stands, there is no certificate of good faith in the record that contains the correct caption with the state actor defendants.
That is my understanding. Yes, Your Honor.
Okay.
I want to talk in my argument today. There's a lot of things in the brief. I certainly can't cover all that. I want to talk primarily about 3 cases. It's the Supreme Court's Myers opinions, and then this court's opinions in the Ledford and Dodson cases. Starting with Myers, most importantly, our Supreme Court told us that the certificate of good faith requirement must be strictly complied with. There is no substantial compliance in this area. And I think that's important because even the claimant in their brief on page 6, they referred to the certificate of good faith having a misnomer, whatever you call that. It's not strict compliance. And the commission in its order recognized that this was not strict. I mean, the commission said it was not defective in such a way, but I think that's a recognition by the commission that there was a defect. And the commission talks in its order about the apparent error described in the certificate of good faith. I don't think either one of those things are strict compliance. And in making that analysis, I think the commission applied a substantial compliance standard to this, which our Supreme Court has told us we can't do. The other thing that I think is important about the Myers opinion is what happened in that case. It was originally filed before this certificate requirement existed. There were expert disclosures. The case was non-suited. It was then refiled after Section 122 was passed, but with no certificate of good faith. That plaintiff argued Well, I had expert disclosures in my underlying case. Everybody knew what was going on. There was a basis for the case. The Supreme Court said that didn't matter. You have to have this certificate with your complaint or the case will be dismissed. And I think that goes to this Miller statement. Even if the underlying information for the certificate of good faith was there, it wasn't filed with the complaint. And just like in Myers, you had this underlying expert disclosures. All the parties knew what was going on in that case and what the bases for the case were, but that wasn't sufficient. You had to have the certificate, and that's missing here as well. The other two cases I want to talk about, the Ledford case and the Dodson case, both from this court. In Ledford, both very similar situations. Ledford, you had a complaint filed in the commission that had a certificate of good faith for a circuit court action, a related circuit court action. There was then a second complaint filed in the commission that had a certificate of good faith, yet for another case. And the Court of Appeals ruled that that case should be dismissed. And they said in that, I want to read this so I get it correct. I think this is important. Back in Ledford, the court said the certificate of good faith must certify that an expert has reviewed the alleged facts and claims specific to a particular defendant, and that the expert believes there is a good faith basis for maintaining a claim against that defendant. And that case was dismissed, at least in part, for failure to comply with the certificate of good faith requirement. Now, there were some other issues in the Ledford case, but part of the dismissal was because of this failure to comply. And the court clearly said that it has to be specific to a particular defendant. Then in the
So
Dodson,
we can't consider this just a Scrivener's error. I mean, it's apparent from the complaint who we were talking about.
Your Honor, the Dodson case I was getting ready to talk about, I think takes care of that. But first, I would say a Scrivener's error, as I addressed in the brief, that's a contract law principle that I don't think can apply to a tort claim in the first place. But an error, whether it's Scrivener's or otherwise, I submit is not strict compliance, which our Supreme Court requires. But more specifically to your question about what's in the complaint, that's what happened in the Dodson case. We had a similar situation where a complaint was filed in the commission. The certificate of good faith was for the related circuit court action. And the commission in that case denied the motion to dismiss, finding that although the certificate did not mention the defendant or either the state of Tennessee or the resident physician who was the state employee, the resident was identified in the complaint. And the Court of Appeals reversed the commission for that in Dodson. They again cited that same language that I talked about from Ledford about it being particular to a specific defendant. But they went on to say that this court said that as far as referencing the certificate of good faith language being present in the complaint, because there it was kind of verbatim in the complaint, this court said that the statute's words clearly and unambiguously require that the certificate of good faith be a document that is filed in addition to and contiguous to the complaint. They talked again about that it has to be a separate document. And then this court concluded that paragraph, and this is from page *4 of the Dodson opinion, said inclusion of the certificate of good faith language within the body of the complaint is insufficient to satisfy the certificate of good faith requirement. And I think in answer to your Honor's question, if having the name of the resident physician in the complaint was sufficient, Dodson would have come out completely differently. And that's why I think this is really the only difference between this case and Dodson is that the certificate of good faith in this case said in the claims commission at the top instead of in the whatever circuit court it was in Dodson. That's the only difference between these two cases. And the name at the very top, whether it's in the commission or in the circuit court, really doesn't make any difference. If naming the resident physician in the complaint had been sufficient, I think this court would have held that in Dodson and affirmed the commission's denial of the motion to dismiss. Instead, the court said you can't take information from the complaint to supplement the certificate and reverse the commission and dismiss the claim. So I think this is really just kind of Dodson all over again, with that only one minor difference that I submit makes no difference because the statute doesn't talk about the forum or anything like that. Now, the other things that since I've got a couple of minutes left, would just mention briefly, the claimant suggested a second issue about whether a caption or style was even required by the statute. This court did not grant that as an issue on Rule 9. Of course, the issues are limited on Rule 9, but even if that is considered by this court, I think it's important to keep in mind two things. First, the statute required the Administrative Office of Courts to produce a form certificate of good faith for Tennessee litigators to use. That form has a caption in it. And they didn't do that just because they thought it was a fun thing to do. It's because that's what's required to identify the defendants, the specific defendants, as this court has said the requirement is, that the certificate of good faith applies to. So that's important. The AOC came up with this form. They included a caption. I think even more important in light of the claimant's arguments is that no caption is required is, if no caption is required, why did they put one on their certificate? They put one on their certificate, and I think every certificate we've seen in the state of Tennessee, or at least all the ones I've seen, have a caption on them because that is necessary to identify to whom the certificate applies. So to address this argument that it's just not required, I think both the AOC's forms, in addition to the words of this court about it has to apply to a specific defendant as a standalone document, but the fact that the claimant included their own certificate of good faith or caption on their certificate of good faith demonstrates that they understood that that caption was a requirement as well. The last thing I want to mention here, although it's certainly not binding on this court, the state cited in its brief the Christian opinion from the Western Grand Division of the Claims Commission. And Christian is this case exactly. You had a healthcare liability claim filed. You had a certificate of good faith with it that said Claims Commission at the top, but it listed the defendants in the related circuit court action. And the commissioner in the Western District applied Dotson and dismissed that case. He did not try to pull the name out of the complaint and put it in the certificate or anything like that. He didn't focus on the fact that it said Claims Commission at the top. He looked at the names of the defendants in the certificate, applied Dotson, and dismissed the case. And although, as I said, that's certainly not binding on this court, I think that is a persuasive example of how Dotson applies to the exact same situation that we have in this case. And with that, I will let the rest of my time go. I think you've probably heard enough of me for today. Thank you.
Thank you, Mr. Walker. Mr. Martin. Wait, there's the clock. Okay.
May it please the court. My name is Randy Martin, and I represent the appellees Edward and Margaret Gilbert in this case. This case is a healthcare liability action. The facts of the case are that Edward Gilbert was diagnosed, went in for a gallbladder removal surgery, and it was performed by Dr. Crawford and Dr. Miles Landry, who is a resident physician, making him a state employee. And following that surgery, Mr. Gilbert developed septic shock. And long story short, he never fully recovered. And months later, a treating physician of his in a surgery found a wad of old silk suture material in his abdomen. And that's the basis for our complaint in this case. And because there was a private doctor and a state employee doctor, as you know, one case was filed in the circuit court and another complaint had to be filed in the Claims Commission. In order to do that, the claimant's counsel obtained a signed written statement by an expert physician stating that he believed, based on the medical records, there was a good faith basis to maintain the action against David Crawford, Surgical Associates of East Tennessee, Miles Landry, University of Tennessee Graduate School of Medicine in the state of Tennessee. And having obtained that fully compliant statement of good faith, which there was no indication from the Claims Commission or from the state, the defendant here in this case, that there was anything wrong with that statement, we went ahead and filed the complaints in circuit and the commission. Now, the certificate of good faith that was attached to the claims commission case listed at the top that the venue was the claims commission for the state of Tennessee. In the caption area, it listed the Gilberts as the plaintiffs, and it listed the defendants from the circuit court case. Everything else about the statement is not being challenged by the defendant. Everything else about the statement was deemed to be fully compliant by the commission. There was no other issues brought up by anyone. So at that point, the state moved to dismiss based on the fact that the certificate did not list either Miles Landry or the state. And as you know from our briefs, that we contend that is not required under the law.
Mr. Martin, let me ask you this. It seems to me that what the Claims Commission said in its order was basically, there's no question that the certificate of good faith contains an error. He called it a Scrivener's error, but the correct defendants were not put in the certificate of good faith. But then he ultimately concluded, well, that's to dismiss it on that basis is an overly harsh result, and claims should be decided on their merits. And while I might agree with that philosophically, the legislature has made it very clear that these certificates of good faith require strict compliance and not substantial compliance. And so my question is, given that there was not strict compliance with the statute, how do we just ignore that language?
Well, our contention is that there was strict compliance with the statute. If you look at the statute, you can see nowhere in the statute does it mention that a caption is required at all, and nowhere in the statute.
No, but it does require the certificate of good faith to certify that, and the language I think is this action, that there is a good faith basis for filing this action. And so knowing that we can't look at the complaint to determine what this action means, how do we determine what this action is from the face of the certificate of good faith?
Well, the certificate of good faith says exactly the language from the statute, that the expert has certified this case as to, it doesn't say as to this action, it says as to these actually, in reality, Section A of the statute lists the language, and there's two choices that you can make as to how you are filing your certificate. Under Section 1, your expert can certify that they believe from the medical records that there is a good faith basis to maintain the action consistent with the requirements of 29, 26, 115. Section 2 is an alternative. It says, or the expert can certify that based on the information available concerning the treatment, that with knowledge of the incident, that there are facts material to the resolution of the case that cannot be reasonably ascertained from the medical records. And despite this, there is a good faith basis for maintaining the action as to each defendant. And that's where that the each defendant part comes in.
This one was under Section 1, correct?
That's right. Yeah. So even if the each defendant part is interpreted to require that the defendants be listed somewhere on that document, that is not the section that controls our certificate. And additionally, what it says, it does not say in the statute anywhere that the defendants listed. It just says that the expert certified it as to each defendant in the case. And we know that the case that it applies to is the case that it's filed with. And that doesn't mean that you have to look to the case itself to fill in missing information. The only case that it could apply to is the one that it is filed with. And as I said before, that part is not even a requirement for the section that our certificate was filed under. And furthermore, as far as the caption goes, the Rule 10 of the Rules of Civil Procedure is the only part anywhere that requires a caption. And Rule 10 says that only pleadings are required to have captions. Rule 7 lists what is included as a pleading. And it lists complaints, answers, counterclaims, things like that. And our certificate is not a pleading. And, Dodson, as this court found in Dodson, that it is a separate document. It is not a part of the complaint. It is attached to the complaint. So this, since it is not part of the complaint, it is not required to have a caption.
So let me make sure I got this correct. So the caption then that you have in your certificate was cover the naming or the identity of the persons that are being sued. Is that correct?
The caption on the certificate of good faith is surplus language that people include generally on the tops of documents that they file. If we filed a motion, we would include a caption at the top, and it might include some or all of the plaintiffs or some or all of the defendants. If there was a mistake with that, it would not mean anything. It would not mean it does not apply to the case. It's not something that's required. It's just helpful in record keeping so that we know what we're looking at.
It just means that you can't identify the case if there's no caption. I mean, eventually you get a docket number and you can do that. But if you're initially filing something and you don't have a docket number, there's no way to identify what this case is and who the parties are unless there's a caption. It's just a random filing.
Yeah, the only party that could possibly be applied to in the Claims Commission is the state of Tennessee. They did not have any question about whether it applied to them because it could only apply to them. And in general, the case that it is filed with will control the case that it applies to. There's not a situation where a motion or pleading has been ruled out other than in this specific kind of situation that because of an error in the caption.
When did you, let me start again. You filed the certificate of good faith with the complaint when you filed your claim, right?
Right.
Now, did you send it along with the notice earlier?
No.
No? Okay.
That's right. No, then the notice only included what's required in that part of the statute, which was the list of providers, the HIPAA authorizations and
Gotcha.
such things. And we think this is respectfully, what we don't want to do right now is tell this court what Dotson means or what it's supposed to mean, but I'll tell you what I take from it. And the reason that I find it to not be controlling or analogous in this situation, and that's because Dotson, like the other cases before it that the state of Tennessee has mentioned, deal with cases where most of them deal with a case where a certificate was maybe filed and the new defendants or plaintiffs or cross defendants were added and a new certificate was not produced for those to cover those defendants. And the reason a new one is needed is because the old certificate could not have certified the case as to defendants that did not exist at the time. And so if the new defendant is added, a new certificate is necessary. Now, in this case, that's not true that we had the certificate, we had the statement of the expert, and that certificate applied to that statement, and nothing ever changed. Now, in Dodson, the difference is that the commission in our case found that the certificate of good faith was compliant. They did not find that it was not compliant. Whereas in Dodson, they did find that it was compliant and then went back to use the complaint to find the missing information. Whereas in this case, that was not the finding of the commission. And additionally, my understanding is that in Dodson, there was no argument that the certificate by itself was sufficient and did represent a statement from the expert that the case was certified. In that case, the argument was that it should be combined with the complaint. And that is not the argument here. The argument here is that the certificate is sufficient and does not need to be supplemented with anything from the complaint. It's also hard to tell what the state argues would be the correct way to file a certificate like this. Whereas many times in their brief they argue that we don't include Dr. Landry's name, and so how would we know if it applied if the statement of the expert applied to Dr. Landry? Whereas a simple caption would not tell the state that his name would not be properly included in the caption. So that would not even cover the situation that they say they have a problem with. And just I guess my time's running out, so I will just finish up by saying what Judge Davis said before, and I hope you'll remember that is the general rule that we want to have cases tried on their merits. And so we would ask that you uphold the decision of the Claims Commission in this case and find that our certificate of good faith was compliant with the statutory requirements that actually exist. Thank you.
Thank you, Mr. Martin. Mr. Walker, you have your rebuttal time. You need to unmute.
Thank you. My Zoom deficiencies come to light for the public. Thank you, Your Honor. Very briefly, just want to address the argument that was made about the certificate of good faith filed with a Claims Commission case can only apply to the state of Tennessee. Therefore, you don't need a caption. Respectfully, I have to say that I think that argument is contrary to the holdings in both Ledford and Dodson, because if that had been the case, in each of those cases, there was a certificate of good faith filed with Ledford and with Dodson from the outset. It was just for the related circuit court cases. But if it had been the case that, well, it's in the commission, so it can only apply to the state, therefore it's clearly for the state, those cases would have come out differently. But instead, both Ledford and Dodson were dismissed because that circuit court certificate that did not identify the state or the resident was held not to be sufficient. And not to repeat myself, but Ledford said it had to be certify claims specific to a particular defendant. And then Dodson went a little further than that, and it said that the certificate failed to satisfy the statute because it did not certify that an expert had reviewed the alleged facts and claims specific to Dr. Brooks, who was the resident physician, state employee, and believed there was a good faith basis for maintaining a cause of action against her. And then again, it cited back to Dodson about the specific defendant. So I think those two cases stand for the proposition, and this business about whether it's the state of Tennessee or Dr. Landry, I think either of those cover it. The state of Tennessee is the actual defendant in the case, but Dr. Landry, of course, the state of Tennessee doesn't do anything. It can only act through its employees. Dr. Landry is the state employee alleged to be negligent. So either of those, I think, would suffice. Dodson does specifically mention the resident, Dr. Brooks, but I don't know that that's determinative. So I think that's all I can say about that. Is I think this issue has already been addressed by Ledford and Dodson, most specifically Dodson, And I think that it requires a dismissal in this case. Thank you.
Thank you both. Mr. Hivner, would you please recess court?
Honorable Court is now in recess until 10:30